What's up, y'all? You're watching Union Minded. I'm your host, Eric, and today it is time for another episode of Contract Talk. You already know, you spot the glasses, you already know what time it is. You got to go and grab your contract so that we can read together. We're going to be continuing from where we left off in the last episode. We're going to continue with Article 2, Section 2.17. But before we dive in, I'm going to give you a moment to get your contract out. Don't forget to hit the like button, subscribe button, ring the notification bell, drop some comments. Helps with the algorithm, helps spread the word and increase the visibility of this channel, and all that good stuff. And don't forget to share these videos. And without further ado, let's jump on in. So, Article 2, Section 2.17, dues checkoff. The employer agrees to deduct and forward to the financial secretary of the local union, upon receipt of a voluntary written authorization, the additional working dues from the pay of each IBEW member. The amount to be deducted shall be the amount specified in the approved local union bylaws. Such amount shall be certified to the employer by the local union upon request by the employer. So this is basically stipulating that the contractor is agreeing to deduct your working dues and send it to the union. There's a paperwork you fill out for it, but you do that on the first day when you fill out all your paperwork. And also it is saying that when the contractor needs proof of the amount, the local union shall certify that amount to the contractors so that they know there's no funny business going on. All right. Section 2.18, a traveling employer. What does that mean? An employer signatory to a collective bargaining agreement or to a letter of assent to an agreement with another IBEW local union who signs an assent to this agreement may bring up to 4 bargaining unit employees employed in that local union's jurisdiction into this local's jurisdiction, and up to 2 bargaining unit employees per job from that local's jurisdiction to this local's jurisdiction for specialty or service and maintenance work. So that's basically just saying that if a contractor who is signatory to, let's say, Local 24 up in Baltimore gets a job that's in 26's jurisdiction, they can bring up to 4 guys with them to go and complete that job, but no more than 4 for the one job. If they have multiple jobs, they can do 2 per job site. All right. All charges of violations of this section shall be considered as a dispute and shall be processed in accordance with the provisions of this agreement for the handling of grievances, with the exception that any decision of a local labor management committee that may be contrary to the intent of the parties to the national agreement on employee portability, upon recommendation of either or both the appropriate IBEW International Vice President or NECA Regional Executive Director, is subject to review, modification, or rescission by the Council on Industrial Relations. There goes that CIR, the Supreme Court, for us. Section 2.19, union as exclusive representative. The employer recognizes the union as the exclusive representative of all its employees performing work within the jurisdiction of the union for the purpose of collective bargaining in respect to rates of pay, wages, hours of employment, and other conditions of employment. So these contractors recognize the local as the exclusive representative for more than just your wages. That's why they negotiate and try to negotiate different terms every 3 years. But they recognize that it's our local that is negotiating on our part. So therefore it is on us to really advocate for the things that we want to see in our contracts. But if we don't advocate and we just leave it up to folks who aren't working out in the field to figure out what it is that we want, we may find ourselves dissatisfied because we didn't advocate, and so they didn't know what we needed. So we need to advocate hard. Go to the local union meeting and advocate for the things that you want to see negotiated into the contract. All right, that's free advice. Section 2.20, Union Security Clause. All employees covered by the terms of this agreement shall be required to become and remain members in good standing of this union as a condition of employment from and after the 31st day following the date of their employment or the effective date of this agreement, whichever is later. This provision is not applicable where prohibited by law. You know why that last line is in there? Because Virginia is a right-to-work state. And in a right-to-work state, you get to hitchhike on the union. Man, I hope my Virginia brothers and sisters don't do that, because we better than that. We don't believe in that nonsense. But that's why that line is in there. This provision is not applicable where prohibited by law. That's why it's imperative that we kick right to work to the curb in Virginia, and that way we can delete this line, because it will no longer matter. It will be applicable for any of those guys who go to work and enjoy all the benefits of union membership without paying the union membership fees. You know who you are. Here we go. Section 2.21, credit union deduction. Each employer shall participate in a Local 26 credit union deduction plan for any employee who provides the employer with proper authorization. The employer is not obligated to initiate more than one such arrangement for any employee within any 12-month period. So this just says that each contractor has to participate with the Local 26 credit union if one of their employees wants a certain amount deducted from their paycheck to go into their credit union account. They have to provide that. Section 2.22, Stewards Clause. The union has the right to appoint stewards at any shop and or job where workers are employed under the terms of this agreement. This does not state that there is a minimum number of people requirement for a steward. So if you are on a small job and you feel you need a steward, reach out to your local union and ask them for a steward here at 26, because this here doesn't say minimum number of employees. The union has the right to appoint stewards at any shop and or job where workers are employed under the terms of this agreement. The employer shall be notified and furnished the name of the steward. The primary function and job of any worker appointed steward shall be that of a journeyman wireman. The stewards shall be allowed reasonable time during the regular working hours without loss of pay to see that the terms and conditions of this agreement are observed at any such shop or job. No steward shall be discriminated against by the employer because of his faithful performance of duties as a steward, nor shall any steward be removed from the job until notice has been given to the business manager of the union. Again, there's no minimum number of worker requirement. You can get a steward if you feel you need a steward. So if you feel you need a steward, reach out and ask for a steward. Section 2.23. By the way, that's why we read these agreements, so we know what our rights are. Section 2.23, voluntary cope contribution. This is a political action. The employer agrees to deduct the amount of 5 cents per hour for each hour worked from the wages of those employees who voluntarily authorize such deductions. So you got to fill out a little card. It says, yeah, you can deduct 5 cents per hour and donate it to the Local 26 Political Action Committee. These transmittals shall occur monthly and shall be accompanied by a list of names of those for whom such deductions have been made and the amount deducted for each employee included into the benefit reporting form. This one's important. If you feel like politics is important, you should contribute that 5 cents, because it allows for our local to be able to get out there and push for certain candidates to get into office so that maybe we can overturn right to work, you know? Maybe. That's a tough one though. Section 2.24, foreman call by name. The employer shall have the right to call foreman by name provided. Number 1, the employee had not quit. Wait a minute. Oh, let me restart this because I read it all fouled up. Here we go. Foreman call by name. The employer shall have the right to call foreman by name provided that 1, the employee had not quit his previous employer within the past 2 weeks. 2, the employer shall notify the business manager in writing of the name of the individual who is requested for employment as a foreman. Upon such request, the business manager shall refer said foreman, provided the name appears on the highest priority group. And 3, when an employee is called as a foreman, he must remain as a foreman for 300 hours or must receive a reduction in force. So when the company calls by name, they have to maintain that person as a foreman for a minimum of 300 hours. And then they could bust them down to a journeyman. Section 2.25, referral slip. Oh wait, so let's just go over that right quick. So for a foreman call by name, you couldn't have quit within the last 2 weeks. So you had to be, unemployed for 2 weeks. Your business manager has to be notified in writing, and then that that recommendation will go through from the business manager, provided that you're on the highest priority group. And then again, if you are called by name, they got to keep you as a foreman for 300 hours minimum. So 2.25, referral slip. All applicants for employment as wiremen shall present to the prospective employer a referral slip, his or her work history from the Electrical Welfare Trust Fund, reflecting hours worked by employees during the past 3 years under relevant collective bargaining agreements, providing this is in compliance with all local, state, and federal laws applicable to the jurisdiction. Photocopies of the applicant's current journeyman's license and copies of documents sufficient to establish the individual's eligibility for employment under the Immigration Reform Act. All applicants for employment as wiremen shall present to the prospective employer a referral slip. So that's the slip you get at the day room when you're going out for work, when you take a call. His or her work history, and that's coming from the EWTF, reflecting your hours worked over the past 3 years under relevant collective bargaining agreements, providing this is in compliance with all local, state, and federal laws applicable to the jurisdiction. So this is not anything special. Photocopies of the applicant's current journeyman's licenses, makes sense for paid holidays, and copies of documents sufficient to establish the individual's eligibility for employment under the Immigration Reform Act. So that would be like your visa or your social security card, things of that nature. Section 2.26, employers' layoff rights. When laying off employees under section 3.20 below, A, the employer shall have total discretion over who is laid off and who is not within each category in section 3.20A. We'll get to that. And B, the employer may retain an employee who has special skills such as high voltage cable splicing, welding, CDL, a security clearance, or other recognized industry certifications, as long as such skills are required on that job and not possessed by an employee in a higher group. And C, the employer need not lay off an employee who possesses a valid journeyman's license issued from a governmental authority from within the jurisdiction of this agreement, rather than any other employee who does not possess such a license, regardless of their employee's group. So you're not necessarily going to be getting laid off because you have a valid journeyman's license or not. But these are the employer's rights on how they can lay people off. And that procedure will be covered in Article 3, which we will dive into in our next episode of Contract Talk. Important to read your contract and to try to understand it as best as you can. And that's what we're here to do. I hope you found this video informative, and don't forget, the fight is not left and right, it's up and down. It's going to take solidarity to win always. Each one teach one, get out there and reach one, and there can be no union without you and I front and center. Peace.